Right.
All right, the next case to come before the court is State of Ohio versus Janelle Smith. That's 19CA011587. This is a state's appeal. Each side will have 15 minutes to present its arguments. Appellant may reserve up to 5 minutes for rebuttal. Let me know if you wish to reserve any time, and if so, how much. I'll do my best to keep you apprised of your time. We have read your briefs. We're ready to proceed when you are. Just as a reminder, the arguments are being visually and audibly recorded and will be posted online.
Good morning, Your Honors. Lindsay Poprocki of the Lorain County Prosecutor's Office on behalf of the State of Ohio, and I would like to reserve 3 minutes of my time.
All right.
Okay. This is a state's appeal from the trial court's decision to grant Janelle Smith's Crim Rule 29C motion on the grounds that the state failed to prove beyond a reasonable doubt that Smith did not act in self-defense under the burden-shifting changes to Ohio's self-defense statute. Through this appeal, the state is requesting that the court first determine whether the trial court erred in applying the burden-shifting changes made to the self-defense statute through the passage of House Bill 228 to Smith's case when the assault for which she was tried occurred prior to the effective date of the statute. The state submits that Smith was not entitled to those burden-shifting changes since her trial occurred on September 9, 2019, after the statute became effective on March 28, 2019, yet the offenses for which she was tried occurred in October of 2018, well before the statute's effective date. As this court is aware, the self-defense statute previously placed the burden of going forward with evidence of self-defense and the burden of proof beyond or by a preponderance of the evidence on the accused. That self-defense statute was amended on March 28, 2019 to shift the burden to the state, however, to prove beyond a reasonable doubt that the accused did not use the force in self-defense. The state here maintains that these burden-shifting changes do not apply retroactively to offenses that occurred prior to the statute's effective date, but which are tried thereafter. This is based on the longstanding principle found in Revised Code Section 1.48 that a statute is presumed to be prospective in its operation unless expressly made retrospective. A number of appellate courts, including the 2nd, 3rd, 5th, and 10th districts, have previously found that the burden-shifting changes made to Ohio's self-defense statute do not apply to circumstances where the offense occurred prior to the effective date of the statute. Particularly the 3rd district in State v. Williams, which is 2019 Ohio 5381, held that it is the version of the self-defense statute in effect at the time the defendant committed the offense that applies at the defendant's trial. There is also a decision by this court in State v. Brown, which was 2020 Ohio 529, where this court was quoted as saying, quote, "We first note that because the offense in the matter occurred prior to March 28, 2019, the former version of the statute applied at the time of Mr. Brown's trial, and it was therefore his burden to prove by a preponderance of the evidence that he acted either in self-defense or in defense of others."
Attorney Poprocki, what is your response to the argument that the state waived or forfeited this argument? I mean, there was an opportunity to object and the state didn't object.
Correct. And I'm aware that Ms. Smith argues that in her appeal in her response that this was an invited error on the part of the state. And we generally acknowledge the doctrine of invited error. But we've cited to case law that says that even an erroneous request of the prosecutor does not forfeit an error on the part of the trial court to follow the mandates of a statute. And here, the Ohio Supreme Court and statutory law has said that a statute must proclaim its own retroactivity to overcome the presumption of prospective application. That's 1.48, and the Ohio Supreme Court's holding in concilio, I believe, and retroactivity is not to be inferred. And here, the statute, the self-defense statute is silent on retroactivity. As the General Assembly's failure to clearly enunciate or expressly indicate that a statute is to be applied retroactivity should simply end the analysis, and the trial court should have inquired no further into the issue of retroactivity. So the trial court should not have inquired as to the prosecution and the defense as to the issue. And it indicated in its entry that it discussed the issue as to retroactivity and decided that the statute should apply that way, and it applied it that way. Our position is that because the legislature did not express an intent to apply the statute retroactively, the trial court simply erred in applying it that way and should have inquired no further. The trial court, yes?
I took maybe a couple questions.
Okay.
With your appeal period,
Mm-hmm.
so the only thing you're seeking from this court, the only thing you can seek from this court is just a ruling that the trial court got the law wrong. So it's an advisory opinion, basically, to say you're wrong.
Correct. We understand that a criminal 29, a determination on a criminal 29 motion is a final decision, and that we can only appeal the substantive legal rulings of the trial court, and that we cannot overturn the decision of Ms. Smith's conviction, acquittal. So we're seeking to correct the trial court's substantive legal rulings.
Okay. All right. And so then
we're asking that I'm sorry. We're asking that our 3 assignments of error be sustained.
Right, but I guess it seems like when you're talking about sufficiency and so forth, you're looking at facts.
The second assignment of error?
I mean, I've never seen, a advisory opinion on sufficiency. How do we get there?
I think the second assignment of error on sufficiency doesn't look so much at the facts of this case as they're applied. We're asking that the court look to the fact that the trial court applied the statute retroactively, and that prior to the burden shifting changes to the self-defense statute, the self-defense was an affirmative defense upon which the defendant bore the burden of proof by a preponderance of the evidence. And a self-defense claim did not factor into a sufficiency of the evidence analysis. So at the point that the trial court analyzed self-defense in its sufficiency analysis under criminal 29C, we're saying that self-defense analysis was improper. That's our second assignment of error. So that self-defense analysis should not have factored into the sufficiency analysis under the criminal 29C motion. basically, the second assignment of error is somewhat related to the first assignment of error in that the retroactive application of the statute permeated the trial court's analysis of the Criminal Rule 29C motion. And in the third assignment of error, the trial court erred in affording Smith a presumption of self-defense without conducting the proper statutory analysis. Again, the trial court analyzed the self-defense statute as providing Smith a strong rebuttable presumption that she was legally justified in using force in self-defense once she posited some evidence that she acted in self-defense. The words strong rebuttable presumption are written into the trial court's judgment entry at page 5. In doing so, the trial court improperly afforded Hill a self-crafted presumption in favor of self-defense without conducting the appropriate statutory analysis. The presumption of self-defense in the statute is not unbridled. The trial court is required to conduct the appropriate analysis, and here it did not go on to analyze the second portion of the statute, which says that a person is presumed to have acted in self-defense when using defensive force that is intended or likely to cause great bodily harm to another if the person against whom the defensive force is used is in the process or has unlawfully entered that person's residence. The presumption does not apply if the person who the defendant used the force against has a right to be in or is a lawful resident of the premises. The victim was a lawful resident of the residence where the assault here took place, and the presumption of self-defense should not have applied to the defendant in this case. Here, because the trial court applied a presumption of self-defense in favor of the defendant, it improperly affected his sufficiency analysis. There was conflicting evidence regarding the issue of self-defense. The state clearly met its burden of proof under a sufficiency of the evidence analysis at trial, as the jury believed the state's version of the evidence in determining that Smith did not act in self-defense when it found her guilty. However, upon a review of Smith's Criminal 29C motion, the trial court further heightened the state's burden by improperly affording Smith a strong presumption of self-defense. And by doing so, the state submits that the trial court erred. It basically read words into the statute that do not exist. The state submits that the three issues raised by the state are errors by the trial court that need to be addressed by this court, and asks that this court sustain its three assignments of error. Any questions?
Not right now.
Okay, thank you.
Ms. Bremke?
Yes, good morning again, Your Honors. Giovanna Bremke on behalf of Janelle Smith. We are appellee in this case, and this case is all about timing. So I have in my brief a short little timeline of the timing here, but essentially the indictment happened in the incident in this case in October of 2018. We know that on March 28th, 2019, the amendment to the self-defense statute took effect, and this didn't go to trial until September 9th of 2019, well after the change to the statute. The reason that timing is important because a lot of the cases that are cited in the state's brief rely on cases in which you know, I sort of imagine them to be people who were convicted much longer before this statute took effect, and now they are coming back wanting these convictions overturned because there was a change in the statute. People who were convicted in 2018, early 2019, and that's not the case here. We have a case where the trial didn't happen until after the statute took effect. And actually, the day I was going to file my brief in this case, there was a decision out of the 12th district, and so it pushed my filing back by a day. But it's State versus Gloff. And there was a lot of discussion about the timing and the this statute. Probably the most in-depth analysis of the amendment to the statute. And what happened in that case, it's very interesting because the state started their case 2 days before the amendment took effect of the statute, and the state was still presenting their case on the day that the statute was amended. And I believe they actually rested their case that day, and the defense started their case. And what the 12th district had said is that because the state was still presenting evidence on the day that the amendment took effect, that it would apply the self-defense statute. This trial court should have applied the self-defense statute going forward because the state was still presenting evidence at that time. If you look at the actual wording of the statute, it's important to note that it says, if at the time of trial, a person who is accused of an offense, and it goes on, but it doesn't say at the time of the offense. It specifically says it's at the time of the trial. That's the second sentence of the revised code section. And it's also important to note that this self-defense statute has been amended over the years. And it's also been applied, for example, in 1974, it was applied the same way in this case. And I'm going to say that it wasn't applied retroactively, it was applied prospectively. The state keeps saying it was applied retroactively, but the fact of the matter is they're using the date as the date of the offense, and what we know from the wording of the statute is that we need to use it starting at the time of the trial. And it's because it's a proof issue. And again, this is, it wasn't applied retroactively. And so the state cites many cases in a long history of cases about applying retroactively. It was applied prospectively because we look at the burden of proof at the time of the trial. And that's exactly what the 12th district did in that Gloff case that was just in June released. One of the big differences in the Gloff case is that the defendant had appealed and not the state, and also the timing is perhaps even more damning to the defendant. This is a more clear-cut case, and what that court did is it reversed in order for the trial court to instruct on the self-defense. Another instruct differently on the new self-defense law. Another thing is that this court pointed out that the state never objected, it never raised the issue, and in a way it waived its right to now raise this issue. There was plenty of time for the jury instructions to be objected to. The trial court gave the opportunity, and they were actually agreed upon. So the state points to these cases where there's an erroneous request and the trial court shouldn't go along with it. This isn't an erroneous request. It's not anything crazy. And there's certainly case law that backs it up. Like I said, even, this Gloff case didn't come out till later, but even the 1974 amendment where we're applying this prospectively, but using the date of the trial and the wording of the statute where it says at trial. It's a proof issue, and it's I think that makes a difference. It's the burden shifting. So at the time that the trial was started, the state knew that they had the burden because the law had already changed at that point. In fact, it had changed for several months. What you see in the Gloff case is it changed in the middle of the trial, but they still had the opportunity to present the evidence. And in this case, the state knew and should have known that by September of 2019, when the statute was amended in March of 2019, that they would have had the burden of proof. In the law, again, it says at the time of trial. So we would ask that you uphold this decision. Thank you. Any questions? None?
Well, yeah, I guess I do.
Okay.
I'm looking in your second, your response to the second assignment of error, because I guess I don't see the totality of the argument here being just the timing per se. When it, I guess, let me put it this way. Everybody is throwing around sufficiency here. Did the judge apply sufficiency? I'm even going to skip the question that, to me, that I toss around in my head is sufficiency even the right standard to apply under the new self-defense? But did the trial judge even apply sufficiency in his decision-making here?
Yeah, so I believe that the judge did apply sufficiency in this case.
How so?
Well, again, his argument in applying the new it is a unique argument because of the change in the statute and whether sufficiency is the standard. And I don't know that there's case law on that because this is a new statute. But you know, in his decision, I believe that he does apply that standard. Whether that was articulated, I'm not sure, but it was. If you look at his analysis, I believe it was a sufficiency.
Well, let's assume, you know, for purposes of this discussion, that the defense met their burden and brought forth, as the judge found, some indication of self-defense. So now the state had the burden beyond a reasonable doubt of refuting it. The state's evidence to do that was, if I understand, the witness, who was in this case the victim, who said, I did not hit her, I did not, whatever, correct?
No, I believe that there was testimony that there was an argument back and forth.
Okay, fine. And she said she did the razor, right?
Correct.
Because he struck her?
Correct.
And the state's witness denied striking.
No, I believe the testimony was that they were both they had both been, you know, substance abuse users, and that there was a long history of
Let's get to self-defense. Substance abuse users, what's that got to do with the self-defense?
Well, because that was part of the testimony that, again, there was a long, because of the nature, there was this drug sale, and because of the nature of their past history of the drug sale and it being, you know, some violent in nature, that, you know, that I think there was testimony that he had began to punch her, and that's when the razor had come out.
Did he deny punching her?
I don't believe he did, no.
Well, the trial court, regardless, the trial court found he did. The trial court said within the sufficiency analysis, said the victim testified that she just came at him and he didn't punch her, and the defendant testified they did punch her. So why is that just not a dispute of evidence and credibility when the trial court makes that finding?
Yeah. I think, you know, their stories were near identical. And I think that the trial court could, and I think he even says that their version of events were very similar in that you could believe that, and again, I see where you're saying that he denied that he had punched her, but that regardless of that, the trial court had held that all the other events had been consistent with each other. Their testimony was consistent otherwise.
I guess, go ahead. Go on. We're going the same place, but go ahead.
No, all I'm saying is I just don't understand how you can weigh testimony on a sufficiency. I mean, because he said basically, defendant is not, defendant is believable and victim is not. Now, I know this won't overturn the conviction, but if you apply the wrong or apply the law incorrectly in regard to a sufficiency, isn't that, I mean, that is an error of law, right? Because you can't weigh the sufficiency.
I'm sorry, what was that?
You can't weigh the evidence in a sufficiency argument.
Yeah, again, I think that whether he had articulated it or not, and we have I guess the advantage of this, having this trial court's insight, because we do have a written decision, but I do believe it was applied correctly.
You still have more time.
If there's no
there's
other
anything else you
questions,
want.
I can hand it off to Lindsay.
Thank you, Your Honors. I'd like to go to your points about whether the trial court analyzed this under a sufficiency standard or may have done so under a manifest weight standard. That was one of the points I think we made under our third assignment of error, is that the trial court did in fact weigh the evidence and made a credibility determination, and basically took that decision away from the jury that had weighed the evidence, or that had found sufficient evidence that Ms. Smith did not act in self-defense, and found her guilty. The trial court looked at the evidence and took the testimony of Ms. Smith, who said that the victim did in fact strike her, and the victim who said he did not. He made a determination based on that testimony as to who was more credible. And what he said was, I'm sorry?
Does it say that in the judgment entry, that the determination on sufficiency was based on whether or not he punched her? Was there not an altercation going on that could have made her actions regarding the razor self-defense, even though they, in her testimony, occurred after, her actions occurred after he punched her? Do you understand? Is the weighing of those two opposite statements even necessary for the court to determine whether or not there was sufficient evidence? And I'm not going to get into whether or not that was the proper mechanism, but might it be that he could have determined that there was not sufficient evidence of self-defense outside of that controversy?
I don't think the weighing of those statements was necessary.
You do or don't?
I do not think the weighing of those statements would.
Okay.
Oh, okay.
Mm-hmm.
Okay. So I think that would be my answer, is that a weighing analysis should not have occurred. Okay.
So again, see, it gets hard because we can't really look whether or not the court made the right decision or not. You know, it's just a matter whether he applied the right law. So I'm getting a little confused myself with all this stuff. But so you're saying, and maybe I'm wrong, but are you saying that the reason why he shouldn't have made that determination is because that was not the issue in front of him? Because we have to have a legal reason. We can't go on the basis of facts. I don't know. I'm throwing this out, trying to figure it all out.
Right.
And your time's up, but please answer Judge Carr's question.
Okay.
If you can,
Please answer Judge Carr's question.
Okay. I think it all goes back to the issue of whether the sufficiency analysis was the proper mechanism in which to determine this Crim Rule 29. Well, a criminal 29C motion is determined for sufficiency, but was that the proper mechanism in which to apply? Was that the proper standard in which to apply to the self-defense argument? Because the retroactivity issue, which the burden shifting changes should not have been applied to Ms. Smith's case. We're trying to tie it all together here. And those are our 3 assignments of error. The burden shifting changes should not have been applied. That permeated the entire, that's the issue that permeates the entire appeal. That affects everything. That affects whether the sufficiency analysis is proper. That affects his ultimate, what we believe was a weighing. And I think that's how I can best answer that question.
All right. Thank you. Thank you both for your time and for your arguments. We will take the matter under advisement, issue our written decision in due course. It will be mailed to both sides and posted on our website and on that of the Supreme Court. Both of you have a great day.
Thank you. You too.